Welcome everyone, my name is Andrew. This is Article 16, Leave of Absence. Section 1 outlines work protections when conducting union duties. Section 2 makes clear the responsibility for the employee to alert the employer before a leave of absence. Section 3, 3.1 through 3.4, defines the common situations resulting in a loss of license and their results. Section 4 covers maternity and paternity leave. Section 5 gives employees the opportunity to go through a rehabilitation program for alcoholism or substance abuse. Section 6 builds on the Federal Medical Leave Act, or FMLA. Section 7 helps expand upon the role of the employer in the case of off-the-job injury. If you want to skip ahead straight to the reading, go ahead and click on the timestamp in the description. Below, you can find a link to the UPS Teamster contract, or if you have not already, you can also download the UPS Teamster app on Android or the Apple Store. This app includes the contract with a handy search function that allows you to find articles and sections immediately important to your situation. I've also included a shorts link below to help you with installation. Welcome to Day 1 of Blitz. Article 16 can and will save your job if you fall into bad habits. I would call it a one-time lifeline, and everyone makes mistakes clause. I personally know a few drivers that have been through rehab for alcoholism and other substances, and they did get their jobs back. Now, some eventually didn't because some of them fell back into their old ways, but if you do go through rehab using Section 3 and Section 5 of this article, you will be able to keep your job that first time. And I would always recommend that if you do have an addiction, seek help, change the friends you hang out with, and change the places you frequent. Now, on a more happier note, Sections 4 and 6 of this article are true lifelines to you when having children. You know, I know a lot of people are really worried nowadays with having kids because they are pretty expensive to have kids nowadays. But the good news is that if you do end up having a kid, you're not going to lose your job. With the use of FMLA and with the use of Article 16, Section 4, you do get time off to have children, and it's not going to seriously affect you. You'll keep your job. You're protected. And on top of that, with FMLA, which is the Section 6 of this article, it does give you access to up to 12 weeks of unpaid leave to take care of, with your birth of your child or an adoption, or be it your spouse, your child, or your parents have a serious health concern that you need to be involved for. You're covered for that. Moving on with the reading. Welcome back. Come back tomorrow for day 2, and I'll see you next time. Bye. Article 16, Leave of Absence, Section 1. The employer agrees to grant the necessary time off without discrimination or loss of seniority rights and without pay to any employee designated by the union to attend a labor convention or serve in any capacity on other official business, provided 48 hours written notice is given to the employer by the union, specifying length of time off. The union agrees that in making its request for time off for union activities, due consideration shall be given to the number of employees affected in order that there shall be no disruption of the employer's operation due to lack of available employees. A union member elected or appointed to serve as a union official shall be granted a leave of absence during the period of such employment, without discrimination or loss of seniority rights, and without pay. Section 2. Any employee desiring leave of absence from employment shall secure written permission from both the union and the employer. The request for leave of absence shall be made in writing at least 30 days before the day on which the leave is sought to commence. If the leave is not foreseeable, the employee shall submit the written request as soon as possible and shall include an explanation why the leave was not foreseeable. The employer and the union shall respond to the request in writing within 10 days after receiving the request. The maximum leave of absence shall be for 90 days and may be extended for like periods. Permission for same must be secured from both the union and the employer. During the period of absence, the employee shall not engage in gainful employment except as provided in Section 3 below. Failure to comply with this provision shall result in the complete loss of seniority rights for the employees involved. Inability to work because of proven sickness or injury shall not result in the loss of seniority rights. The employee may make suitable arrangements for the continuation of health and welfare and pension payments before the leave may be approved by either the local union or the employer. Section 3. Loss of license. Section 3.1. Leave of absence. When an employee in any job classification requiring driving loses his or her operating privilege or whose license has been suspended or revoked for reasons other than those for which the employee can be discharged by the employer, leave shall be granted for such time as the employee's operating privilege or license has been suspended or revoked, but not for a period longer than 2 years, provided the driver whose operating privilege or license has been suspended or revoked notifies the employee's immediate supervisor before the employee's next report to work of such suspension or revocation. The above provision need only apply to the first suspension or revocation except for suspension of commercial driver's license of 1 year or less duration. Employees who take a leave of absence under this section whose loss of operating privilege or license is the result of driving under the influence of drugs or alcohol shall be allowed alternative work and to return to their job in accordance with Section 3.3 below. Section 3.2, alternate work, other than alcohol, controlled substance. When an employee in any job classification requiring driving has lost his or her license under this article, he or she shall be afforded the opportunity to displace junior, 1 full-time, or 2 part-time inside employees until he or she can return to his or her driving job, not to exceed 2 years, unless provided for otherwise in the supplements, riders, or addenda. The employee shall receive the appropriate rate of pay for the job performed based on his or her seniority. Coverage for benefits shall continue for the length of the leave of absence or for the job duration up to 2 years. Section 3.3, alternative work, alcohol, controlled substance. When an employee in any job classification requiring driving has lost his or her license for driving under the influence of alcohol or a controlled substance, he or she will be offered available inside work of 1 full-time or 2 part-time openings not to exceed 2 years, provided that the employee is assessed by a substance abuse professional, SAP, and is released to return to work by the SAP. The SAP shall establish the terms upon which the employee may return to work. The employee must also enter a rehabilitation program, if required by the SAP, within 1 month of the SAP's assessment. The employee must also enter a rehabilitation program, if required by the SAP, within 1 month of the SAP's assessment. The employee shall be returned to driving once he or she successfully completes the rehabilitation program, provided his or her driving privileges have been restored. The employee shall receive the appropriate rate of pay for the job performed based on his or her seniority. Coverage for benefits shall continue for the length of the leave of absence or for the job duration up to 2 years. Any driver cited for driving under the influence who does not have his or her license suspended or who has limited driving privileges shall be assessed by a SAP within 5 working days of the citation. If the SAP determines the driver does not require rehabilitation, then he or she shall be allowed to return to driving. Until the assessment is completed, the driver shall be allowed to work at his hourly wage and guarantee. If rehabilitation is required, the above paragraph shall also be applicable. The right to rehabilitation provided in Article 35, Section 4.11 shall not be applicable to a driver who completes a rehabilitation program under this paragraph unless, as a result of the DUI citation, the driver is convicted or loses his or her license for driving. This section does not apply to the employee that has lost his or her license for being disqualified for testing positive for controlled substances. Section 3.4, CDL Qualification. This article shall also apply in the event an employee is unable to successfully pass the DOT Commercial Driver's License, CDL, examination provided the employee makes a bona fide effort to pass the test each time the opportunity presents itself. Section 4. Maternity and Paternity Leave. It is understood that the maternity leave for female employees shall be granted with no loss of seniority for such period of time as her doctor shall determine that she is physically or mentally unable to return to her normal duties, and maternity leave must comply with applicable state and federal laws. A light duty request, certified in writing by a physician, shall be granted in compliance with state or federal laws, if applicable. Light duty requests shall also be made through the employer's Light Duty for Pregnant Workers program. Paternity leave shall be granted in accordance with Section 6 of this article, with the exception of employees not able to meet the qualifications set out in Section 6, who shall be granted leave not to exceed 1 week. Notwithstanding any provision to the contrary in any supplement, rider, or addenda, an employee shall be allowed to designate in any vacation year paid time off up to 20 days to be used in the next vacation year in accordance with this paragraph. Any paid time off that is provided on a weekly basis can only be banked in weekly increments. The accrued paid time off may be used in the next vacation year to cover any period of time that 1. The employee is determined to be unable to perform her job due to pregnancy. For the father, time off is requested due to the birth. And 2. Is not covered by the FMLA, existing disability plans, or other paid time off. If the accrued time off is not used in that year, it will be paid to the employee within 2 weeks of the request. If the vacation is not used as part of the leave, and it would have originally been taken in that vacation year, the employee shall also have the option of rescheduling the unused vacation as time off in accordance with local practice. Section 5. Rehabilitation Program Leave of Absence. An employee shall be permitted to take a leave of absence for the purpose of undergoing treatment in an approved program for alcoholism or substance abuse. Employees may use the United Parcel Service Employee Assistance Program, EAP, a union-sponsored rehabilitation program, as well as any other referral service in choosing an approved program for treatment. Employees shall be permitted to take advantage of a rehabilitation program once every 5 years, 3 times lifetime maximum under all conditions of this article. The leave of absence must be requested prior to the commission of any act subject to disciplinary action except as provided in Article 35, Section 3, and Section 4. The leave of absence shall be granted for a maximum of 90 days. Additional time may be granted if it is mutually agreed between the company and the union or requested by the substance abuse professional. While on such leave, the employee shall not receive any of the benefits provided by this agreement, supplements, riders, and/or addenda, except the continued accrual of seniority. If an employee voluntarily enters such a rehabilitation program under the provisions of the article, the following shall apply. 1. Before returning to work, the employer shall ensure that the employee is alcohol/drug free. This requirement shall be satisfied when the employee has provided a negative drug test result as per cutoff levels contained in Section 3.3 or Section 3.4 of Article 35, as applicable, and/or an alcohol test with an alcohol concentration less than 0.02. The employer will make all reasonable efforts to conduct all return-to-work testing, conference calls, and examinations within 5 working days of completion of a rehabilitation program. Within 1 year of the date on which an employee returns to work, the employee may be subject to unannounced alcohol/drug testing as specified in the return-to-work agreement. The 1-year period may be extended only by the SAP and must be substantiated by written verification of the SAP. 3. Unannounced alcohol drug testing for the above-mentioned employee, if required, shall be determined by the SAP as provided in this article. The date, time, and place of collection for alcohol/drug testing, if required, shall be determined by the SAP. 4. Failure to comply with the aftercare treatment plan or a positive specimen as part of the aftercare treatment plan will result in discipline pursuant to Article 35, Sections 3.13 and 4.11. All alcohol drug treatment agreements, including pre-care, aftercare, and return-to-work agreements entered into shall be confidential and signed by the employee and the SAP overseeing the treatment program and must have been approved by the local union business agent prior to the employee's signature. The post-care agreement shall comply with all provisions of this article. The employer agrees to recognize the employee's right to privacy and confidentiality while being party to such an agreement. The employer agrees that in all circumstances, the employee's dignity will be considered and all necessary steps taken to ensure that the entire process does nothing to demean, embarrass, or offend the employee unnecessarily. Section 6. Family and Medical Leave Act, FMLA. All employees who have worked for the company for a minimum of 12 months and worked at least 1,250 hours during the past 12 months are eligible for unpaid leave as set forth in the Family and Medical Leave Act of 1993. Additionally, any employee not covered above that has worked for the company for a minimum of 36 months and accrued at least 625 paid hours during the past 12 months is eligible for unpaid leave as set forth below, except that the amount of leave allowed will be computed at 1/2 of the time provided by the FMLA. Eligible employees are entitled up to a total of 12/6 weeks of unpaid leave during any 12-month period for the following reasons. 1. Birth of a child. 2. Adoption or placement for foster care. 3. To care for a spouse, child, or parent of the employee due to a serious health condition. 4. A serious health condition of the employee. The employee's seniority rights shall continue as if the employee had not taken leave under this section, and the employer will maintain health insurance coverage during the period of the leave. The employer may require the employee to substitute accrued paid vacation or other paid leave for part of the 12/6 week leave period. The employee is required to provide the employer with at least 30 days advanced notice before FMLA leave begins if the need for leave is foreseeable. If the leave is not foreseeable, the employer is required to give notice as soon as practicable. The employer has the right to require medical certification of a need for leave under this act. In addition, the employer has the right to require a second opinion at the employer's expense. The provisions of this section are in response to the federal act and shall not supersede any state or local law which provides for greater employee rights. Section 7. Disability. When an employee is injured off the job, the company shall use its best efforts to provide the employee with all necessary documents and reasonable assistance in order to assist with the processing of the employee's disability claim.